Well, he has never lost being an MP as far as I'm concerned, because the decision of the High Court has not been fully implemented, as far as I know. If it has been fully executed, then, of course, he's no longer a member of parliament, in which case he's not a former either. But if it is not fully implemented yet, as we speak, then I can understand that he is still not completely a former member of parliament. He's still on his way out, but not completely out. And in which case, his situation is a bit dicey and quite unsettled at this point. And so, for me, I'm happy with this outcome, and I commend the Supreme Court for such a thoughtful decision. It sanitizes the system for all of us. Going forward, and it is a momentary decision that would usher all of us into the final outcome post 16th of January. Then the new date may be set. Depending on the outcome, a new date may be set by the Electoral Commission, either to rerun or the entire judgment of the High Court completely quashed, and the matters before that decision remains. The status quo ante kicks in which case Kpandai goes with their old member of parliament. And so I think for all of us, either those of us watching from the fence and those who are directly affected, nobody goes home unhappy because of this decision, because it's a fair decision. It enables all the drawing cards to remain on the table, awaiting the final outcome of the Supreme Court's decision. Let's all remember, as I indicated, a certiorari application has the potential of completely quashing the entire decision of the High Court. Similarly, it could also reaffirm the decision of the High Court. And so it is just right that we hold on to our horses, await the outcome of the decision when it eventually comes out. And then we can all proceed as a nation.
Abdullai, while we wait, though, I need some bit of clarity. So now Matthew Nyendam was declared a persona non grata by his opponents, the NDC in Parliament. He was given until December 1st by the Speaker, which after he, according to the Speaker, ceased to be a member of Parliament. And you're saying that he's not out of the House yet. So if the House sits tomorrow, can he enter the chamber as an MP?
No, that's not what I said. I said I don't know the extent to which the execution of the High Court judgment has gotten to. And my point was that if it is fully executed, then there's no member of parliament. He cannot have any locals in parliament. But my point remains that once the rerun has been suspended, and in fact, if you take it from that angle, that is only the rerun that has been suspended. If you take it from that angle, then it means that he's actually not a member of parliament. It means that the whole execution process is done. So the wording of the Supreme Court decision would have a lot to tell about the status quo of the position of the member of parliament, the outgoing member of parliament, or whatever status you want to put in. And so the wording would be very crucial in determining that. But I'm assuming, like I said, if you assume on the basis of the intention to rerun the election, then you could clearly see that maybe the entire execution has taken place, in which case he is no longer a member of parliament. But he's not completely out yet until the final determination by the Supreme Court. Because once the Supreme Court comes out to say that he is no longer in office, then that's it, and or questions the decision of the High Court, then he can go back to Parliament. If they don't question it, then he goes, he leaves Parliament completely.
The Supreme Court has given. Sorry about that. The Supreme Court has given 7 days for substitute service. What happens when that 7 days elapse and they are unable to serve him?
Well, if they're unable to serve him, unfortunately, it means that I don't know the consequential orders that the Supreme Court made, but I'm assuming that if the Supreme Court has made that order, they may have to find a way of serving him, and they would have to achieve that either through if it is substitute service, that I'm sure the orders have been spelled out as to what the mode of service that should be implemented. It could be through WhatsApp. It could be through the party apparatus, or through Parliament. It could be through several means, or all of which would be determined by the mode that the Supreme Court has spelled out in making the orders. So if they follow these, then it means that the 7 days would have been achieved. If they don't follow, they may have to go for further directions from the Supreme Court. But I doubt that cannot be. That cannot happen from now to the 7th day, because I'm assuming that the mode of service was also spelled out in granting the substituted service. And so, having said that, it literally makes the 16th or the 13th of January a fixed date for the Supreme Court to come out with their final decision on this matter. Once they have become seized with this case, I'm assuming that they have read all the arguments, all the affidavits in support. And so on that day when the parties appear, their job will be very, very little. They may, making their submissions, the courts may change their mind on whatever they might have decided based on the papers filed or the processes filed, or may affirm their intended decision having read the processes already filed before them.
Is a law lecturer. Thank you very much, with the University of Professional Studies Law School.